Hello everyone, welcome to LawPutra YouTube channel, and our topic for today is workmen and its different kinds. Now workmen is defined under section 2S of Industrial Disputes Act. The section 2S states that workman means any person who is employed in any industry to do any manual, technical, skilled or unskilled work or operational, clerical or supervisory work. Further, the section states that workmen also includes persons who has been dismissed, discharged or retrenched in relation to any industrial dispute or as a consequence of an industrial dispute. Thus, this means that just because a person has ceased to be an employee, that does not mean that he ceases to be a workman for the purpose of the act. He would continue to be considered as a workman for the adjudication of his rights. Now, section 2S, further 2S contains list of persons who would not be considered as workmen. These include persons to whom the Army Act, the Navy Act or the Air Force Act applies. So that means persons employed in the armed forces of India, they would not be considered as workmen. Similarly, persons who are employed in any of the police services in India will also not be considered as workmen, and also persons who are employed to do any prison work, they would also not be considered as workmen. Further, it says that persons who are employed in any managerial or administrative capacity in any industry, they will also not be considered as workmen. Fourth point, it says that people who are engaged in supervisory work. However, the section 2S states that persons who are engaged in supervisory work will be considered as workmen. The exception states that if a person engaged in supervisory work draws salary of more than 10,000 rupees, then he would not be considered as a workman. Now, a very crucial aspect of to be considered as a workman is that there must be a master-servant relationship between the employer and the employee. And secondly, there must be an element of reward. That means the workman or the employee must get something in return for giving his services. If there is no relationship of master or servant and there is no relationship of reward or consideration, then he would not be considered as a workman. So let's say if there's an industry and they have engaged certain interns, those interns will not be considered as workmen. For example, in the case of PNB versus Gulam Dastagir, the area manager of PNB had employed a driver so that he could drive his jeep. Now the PNB was giving the area manager the allowance so that he could employ a driver for his use. However, within the records of the PNB, there was no mention that he was the driver or he was not even employed directly by the PNB. Rather, the area manager was getting the allowance, and through that allowance, the area manager had employed a driver. Now, in this case, Supreme Court had held that the driver will not be considered as an employee of the PNB and thereby not be considered as a workman. This is because the driver has been employed through the area manager and not directly by the PNB. Thus, there must be a direct relationship between the direct employment relationship between the employer and the employee. Now, there may be cases, especially in the category of people who are considered as workmen, that they might be given multiple jobs, since these are not very highly skilled or highly technical jobs. So they might be given multiple jobs. In such a case, a question arises whether a person who has been engaged as a workman and his job profile matches that which is mentioned section 2S, but he is given temporarily an additional charge which may be of administrative or supervisory nature, then will he be considered as a workman or not? In such a case, the primary and the basic duties of that particular workman will determine whether he is considered as a workman or a normal regular employee, even if he has been given some additional charge. Therefore, if a person or any employee has been incidentally given certain duties which are not strictly in line with his basic duties or his main function, then he would not be considered as a workman. For instance, in the case of J. Phillips versus Labor Court Hyderabad, the court had clearly stated that the test to decide whether an employee is a workman or not is to consider his basic and primary duties and dominant nature of his employment. Simply because a person has been given any additional duties will not alter or change the dominant character of his employment, and that dominant character will be instrumental in deciding whether the person is a workman or a normal employee. For example, let's say there's an industry and they have employed certain clerks, multiple clerks are there. Now within those clerks only, a, a person who is very senior among the clerks might be designated as head clerk. So when he's designated as head clerk, he might be given certain additional powers, let's say, which are in the nature of administrative, right? So for example, he might be responsible for distributing works to various other clerks. Now, in this particular case, the dominant nature of his work is clerical, which is in line with the Section 2S of the Industrial Disputes Act. So, he will consider as a workman despite he being given a managerial or an administrative capacity work, which is the designation of head clerk. Again, let's say if a work profile requires something which is creative in nature, he has to do some sort of creative work, then in those cases also a person will not be considered as a workman. For to be considered as a workman, strictly requirements of Section 2S need to be followed. Therefore, a legal assistant will not be considered as a workman, since that particular job profile requires creative work. It requires his own application of mind and various very highly technical skills. Now, a very important question which comes is that whether an independent contractor can be considered as a workman or not. Now, as I had said earlier, in order to be considered as a workman, the employee, the supposed employee, must be directly recruited by the employer. There must be a direct relationship, which is not so in case of an independent contractor. The independent contractor, as the name suggests, is independent of that particular uh, employer or the organization. He is free to do the task the way he prefers. However, certain guidelines he has to follow, which is given by the employer. But as such, the employer cannot control the way of working or the manner of working. So, an independent contractor and all those persons who have been employed by the independent contractor will not be considered as workmen of that particular employer or particular industry. The definition of workman is very important. This is because the Industrial Disputes Act applies only to a workman. So let's say if any dispute arises between the employer and the workman, it is only the workman of that particular industry, only he can file an action against his employer and the industry. No other employee will be entitled under the Industrial Disputes Act. He might file cases under some other law, but under the Industrial Disputes Act, only the workman can do. Thank you.